Hello, my name is David Bainton and I'm a partner and head of the Bristol employment team at 𝗃𝗏𝗄. I'm delighted to be joined today by John Miles, a tax director at Richardson Swift. The number of employees working from home has grown exponentially as a consequence of the pandemic. In this webinar, John and I will be considering some of the legal and tax issues and the practical considerations for employers that may or will arise as a consequence of home working and hybrid working. This will be a very high level 20 to 25 minute presentation on just some of the issues we suggest you should be thinking about. So what is a home worker? There's no definition of a home worker under the Employment Rights Act 1996, but home working can take various forms. It might be someone who works exclusively from home on a full-time or part-time basis. It might be someone who works from home regularly, dividing their time between their home workspace and their employer's premises. Or it might be someone who works on an ad hoc, occasional basis from home. Whatever the arrangements, home working or hybrid working arrangements you are entering into or considering entering into, you will need to address several practicalities. Plainly, some of the provisions of your employment contracts may need to be tailored or updated to reflect any new operating model. Before I provide some examples, I would just make the point that if you are seeking to make any changes to employment contracts, various legal and practical considerations apply, particularly if an employee is not willing to consent to those changes. It's outside the scope of this webinar to go into those considerations in detail, but I just wanted to flag this up. Some examples of some contractual provisions that may need to be reviewed. Place of work. Section 1 of the Employment Rights Act provides that you must provide particulars of an employee's place of work, and if that changes, Section 4 of the same Act requires you to provide updated particulars. A shift from a workplace-based working arrangement to a home-based working arrangement is almost certainly going to trigger Section 4 of the Act. Clarity of expectations is key, and that's going to be a theme throughout this webinar. As I mentioned earlier, home working can take various forms. So you need to consider, will there be a minimum number of days that the employee will be working in the office? Will those days be set days, or will there be some flexibility there? I suspect in all cases you will want staff, or at least to have a right in the contract to require staff to come in to the office on occasion for certain reasons, such as attendance at client meetings. But this all needs to go in the contract. What about the employee's working hours? Are you going to be prescriptive about this? Are you going to be completely flexible? I know some employers will have core hours in which the employee has to work, but then they are flexible outside of those core hours. Plainly, you need to be mindful of any employees who've got childcare or other commitments, as this may impact on their ability to work certain hours during the day. Again, there needs to be clarity of expectations in either the employee's contract or any relevant policy. The usual working time limits will apply to home workers as they would to workplace-based workers. There was a European Union study undertaken during the pandemic that found that those working from home regularly were twice as likely to work more than 48 hours a week. You need to have mechanisms in place to monitor this, and you also need to ensure that you have adequate records of the hours being worked by your home workers. You need to keep an eye out for any signs that the employee is working excessive hours, for example, consistently emailing outside of their normal working hours. Failure to take reasonable steps to do so can amount to a criminal offence, as I'm sure many of you are aware. I would suggest you may wish to specify in the contract or policy that those working from home are responsible for regulating their own working time and taking appropriate breaks. What about expenses? What is your position going to be on a home worker's expenses? A home worker may incur expense travelling to and from the office. Undoubtedly, their bills will go up, their telephone, broadband, heating, etc. There's no legal obligation on an employer to reimburse those expenses, but you need to set out your position clearly to your staff. And the ACAS Working from Home Guide recommends employers consider any extra costs employees might have when working from home and discuss who's going to pay those costs with the employees and their representatives. Confidentiality and data protection. I would suggest that it will be more difficult to police confidentiality when an employee is working away from the office. You need to have clear policies, procedures and guidance for staff who are remote working, and you should put in place measures to help keep information secure. For example, strong passwords, encryption, only allowing approved technology for handling personal data. You may also need to consider specific training for home workers on their obligations in relation to data protection. The ICO, the Information Commissioner's Office, has produced guidance to help ensure there is compliance with data protection law when working from home, and I will include a link to that guidance at the end of this webinar. You should do a data privacy impact statement to help identify and minimise the data protection risks of working from home. This could include, for example, who is going to access any device that the employee is using. Probably easier to control that if it's a company issued device, and the personal data on the device. And what measures are you going to put in place to ensure other members of the employee's household will not have access to the device? What about employee monitoring? If you're going to change your monitoring practices, you'll need to inform employees of those changes. The ACAS Working from Home Guide recommends that employers carry out an impact assessment to decide if and how to monitor their staff. The same guide and the ACAS Hybrid Working Guide also recommends consultation with employees and any representatives before introducing any form of monitoring. You must tell employees about the monitoring arrangement that you have in mind and your reasons for it. You will also need to review any internal procedures such as your disciplinary and grievance process and your appraisals process. I'm sure all of you are now well used to conducting meetings by Teams and Zoom, but there's also things like managing and measuring the performance of an employee working from home. How do you do that if they're not in the normal workplace? The ACAS Hybrid Working Guide stresses that home workers should be given access to the same support, which includes access to their reps, i.e. a recognised trade union, and also the same opportunities for training, development and promotion. That said, it may be perfectly legitimate to take the position that a home worker cannot be assigned particular tasks or be considered for certain promotion opportunities, but you just need to be in a position where you will be able to objectively justify your position on that in case you're faced with a discrimination claim. In terms of health and safety considerations, obviously the same duty of care will apply to home workers that is owed to workplace-based staff. You will need to conduct an appropriate risk assessment of the work activities carried out by your home workers, as you would with your workplace-based staff, to identify and assess the degree of any risks. I know many of my employer clients undertook risk assessments during the pandemic, but I would suggest you will need to revisit those assessments if you're now considering allowing home working on a more permanent basis, as I suspect those risk assessments assumed temporary home working arrangements. And you should review any health and safety policies to ensure they fit with your new working model. What legal protection do home workers and hybrid workers have? Well, there's no automatic right to work from home or from any other working location. And being a home worker is not a protected characteristic under the Equality Act. However, there is various employment legislation that may apply when you are dealing with a home worker or a hybrid worker. You need to be mindful of the risks of discrimination claims that may arise when dealing with a home worker or a hybrid worker. It would be directly discriminatory, contrary to Section 13 of the Equality Act 2010, if, because of a protected characteristic, A treats B less favourably than A treats or would treat others. The ACAS Hybrid Working Guide gives the following example of direct discrimination in a hybrid working scenario. For example, an employer accepts a hybrid working request from a male employee who has children. The employer refuses a similar request from a female employee because they think she'll be distracted by her children. This is direct discrimination. There is also a risk of indirect discrimination in relation to your approach to home working and hybrid working. If any policy or practice you implement has a disproportionate impact on people with a protected characteristic, you'll need to ensure that your approach is justifiable as a proportionate means of achieving a legitimate aim. Again, the ACAS Hybrid Working Guide provides a useful example of indirect discrimination. For an example, an employer does not allow hybrid working for anyone in a particular role, so it's not direct discrimination because it's applying to anyone in a particular role, irrespective of whether they have a protected characteristic. This disadvantages an employee who is disabled and finds it difficult to travel to the workplace every day. Because the employer does not have a good business reason for the decision, this is indirect discrimination. If you are dealing with a disabled employee, you have a duty to make reasonable adjustments in relation to disabled persons, as I'm sure you're all well aware. And permitting and facilitating working from home may well amount to a reasonable adjustment depending on the circumstances. Assigning the disabled worker to a different place of work or training or arranging home working is included as an example of a step it may be reasonable for employers to take in the Equality and Human Rights Commission's Code of Practice. Unfair dismissal. If you dismiss a home worker or a hybrid worker for refusing to return to workplace-based working, for example, they may have an unfair dismissal claim depending on their circumstances. And indeed, I have a couple of cases on at the moment where precisely that happened. The usual unfair dismissal criteria and principles will apply. A home worker could also be constructively dismissed, for example, if you mishandle their flexible working request to such an extent that your conduct amounts to a fundamental breach of contract. Very briefly on employment status, it's outside of the scope of this webinar to discuss how employment status is determined, but I just wanted to make the point that the employment protection available to home workers and hybrid workers will depend on whether they're self-employed, an employee or a worker. For example, the statutory right to flexible working, which I shall be speaking about in a moment, and unfair dismissal protection only applies to employees, whereas discrimination protection, for example, would apply to workers as well. So finally, flexible working. Again, the flexible working legislation does not give employees a right to work from home or change their existing working arrangements, but it gives qualifying employees the right to request flexible working arrangements, which can include the place at which they work. Indeed, Section 80F of the Employment Rights Act 1996 expressly includes changes relating to whereas between his home and a place of business of his employer, the employee is required to work. When considering working from home and hybrid working, you should discuss how other types of flexible working might help an employee. ACAS gives an example of an employee who worked from home during the COVID-19 pandemic. This allowed that employee to save money by not commuting and to better look after their children. However, they sometimes felt lonely and found it difficult to collaborate on some work. The employee does not want to return to the workplace full time, and ACAS suggests that you could consider in that scenario offering hybrid working and flexible working hours to help with childcare. But essentially, you just need to deal with such requests as you would any other flexible working request. There's nothing different or special you need to do because it is a home worker, other than being mindful of the risk of discrimination claims, as I mentioned earlier in this webinar. You should understand why the home worker is making the request. It could be a request for a reasonable adjustment under the Equality Act. But again, this is the case with any flexible working request. It may be harder for employers to refuse flexible working requests for home working or hybrid working, where this has been arranged during the COVID-19 pandemic on a temporary basis, and that has worked well. And the ACAS Flexible Working Guide states that it's important for an employer's decision to be based on facts and not personal opinion, in other words, objective. Having said that, the legislation suggests the test is in fact subjective. It is sufficient that you believe one of the 8 permitted grounds to reject a flexible working request applies. That concludes my portion of the webinar, and I will now hand you over to John.
So thank you, David. I'm going to summarise some of the tax and national insurance rules that currently apply for employers and employees in the area of the main expenses that are arising from home working. But before I do that, I just want to have a recap to put this in context of the rules that applied during the pandemic, which some of you may be very aware of and perhaps no doubt even had to apply. In effect, the government brought in a temporary exemption and relaxation to the previous rules with effect from 16th of March 2020. But it's important to note that that is now no longer in force and will not be extended from the 5th of April 2022. So we're now in a current year where we have the new rules, which I'll come on to in a moment. In effect, in the pandemic, we went back to previous rules, but with some relaxations. And the main relaxation was that the employees who were suddenly forced to work at home were able to undertake expenditure on, for instance, office-based equipment so that they could work at home, seek a reimbursement from the employer and not be taxed on it. There were various conditions, such as the equipment had to be solely used for the purpose of the employee's duties, and technically an advanced agreement was supposed to take place between the employee and the employer, but generally it was very favourable. In addition to equipment, there were household expenses to consider, such as light, heat and electricity. Previously, there had been a flat rate of £4 per week that employers could pay to employees, tax-free. During the pandemic, this was increased to £6 per week as a flat rate with no need for records to prove the expenditure. I'll come on to this in a moment in terms of the current rules, but needless to say, the £6 per week actually still applies, subject to whether the employee is actually now home working in inverted commas, which is something David mentioned. The home working was also for an indefinite or limited period, so it was quite flexible. One practical question that I just want to cover here that no doubt some of you would have already had to encounter is what happens or happened when an employee who was working at home during the pandemic using equipment in their home. What happens when that person returns to their usual place of work, for instance, the office? In particular, what happens in respect of that equipment and the tax implications? So this falls into two categories. Firstly, if the employee purchased the equipment during the pandemic, they are basically able to keep the equipment at home without a tax charge or national insurance charge. The converse of this is that if the equipment was provided for the employee by the employer, which basically means for the purpose of this webinar that the employer paid for the equipment, then there are two possible scenarios. Firstly, there is no charge if the equipment can be returned back to the employer, but this brings up questions of space, transportation, practical issues now, because since the pandemic, it may be that the employer has reorganised their office space or reduced it, and it may not be practical for that employee to return the equipment back to the employer. They may not want it. The second scenario is that tax and national insurance will be due if the employee keeps the equipment. This is, on the face of it, quite unfair because the employee often had no choice but to have the equipment provided for them. For instance, a special chair for back problems where there was no office chair available at home. And clearly they had to work safely. So this throws up a very practical challenge for the employer and the employee, because HMRC have confirmed at the moment that this unfavourable tax treatment does apply. So there will be a tax charge on the employee based on the market value of the asset at the time that the employer requested the employee to come back to work and the employees retained the equipment at home. The employee is taxed through the P11D system, but there could be employment law issues to consider here in terms of that extra tax cost to the employee. It may be that the employer agrees to pay extra salary to fund the extra tax, but again, the employment law position will need to be checked. So what is the current position regarding the taxation and national insurance treatment of the typical expenses that arise as a result of the current home working and hybrid working that we're more accustomed to see now following the pandemic? Well, as I've said, the temporary exemptions brought in during the pandemic are no longer in force and they will not be extended beyond the 5th of April 22. So we're currently in a tax year under the new rules. And in effect, certainly for equipment, and I'll come on to home working expenses in a moment, we go back to the pre-existing rules before COVID, albeit with some changes and a few grey areas going forward. As we've said already, more employees are working from home and there's more hybrid working, but I think as David's already alluded to, there is no current definition of home working. The Office of Tax Simplification did publish a paper in July 22, which may have led to a definition being agreed, but you may have heard in the recent mini budget that that organisation is now to be disbanded. And so we have to watch this space for possible definitions of home working for tax purposes. In terms of equipment, a bit like the position before COVID, there are some specific exemptions, in particular for employer-provided equipment, as we've mentioned in brief before, such as laptops and computers, where they are only used for business and the private use is very insignificant or incidental. In that case, there is no tax or national insurance. Mobile phones and SIM cards have their own rules, and these are exempt on a one item per employee basis if the employer has paid for it in the contract. In terms of what is significant or insignificant private use, HMRC take a reasonable view, or at least this is what they've said they will do, and they have confirmed that detailed records will not be needed to be kept by the employer, logging the use or the private use by the employee. But what they have said is that they expect the employers to have a very clear policy that governs the use of employer-owned assets. If, on the other hand, equipment is provided for both personal and business use, then, broadly speaking, the cost of providing that equipment is a benefit in kind on the employee, typically taxed through their code as income. And you will need to capture this as an employer on Section L of the P11D, and Class 1A national insurance will be payable on the benefit by the employer as well. One item of expenditure that sits very much on its own and quite often comes up as a question is broadband. And basically, where an employee does not have a broadband connection, under the current home working and hybrid working arrangements, if they are required to work at home, and to do that they need a broadband connection, then the employer can reimburse part or all of that cost, and that would be tax and national insurance free. However, if the employee has a broadband connection already, then should the employer choose to reimburse, and that is something I think that David mentioned earlier, there would be a tax and national insurance charge on any reimbursements. Otherwise, the general rule for expenses is that the employee needs to be obliged to incur the expense for their duties, and the actual expenses are incurred wholly, exclusively, and it has to be necessary for their employment duties as well, for them to be able to claim a deduction. For specific home working expenses, substantive duties must be at home and cannot be performed without appropriate facilities. Those two conditions are probably fairly easy to meet, but HMRC's interpretation of the legislation is that two further conditions need to be met. And that is that basically the employee does not have the option to work at home, and there are no appropriate facilities on the employer's facilities for them to do the work in the office. These last two conditions are, as I say, are not in the legislation, but it's just HMRC's interpretation. It should potentially be challenged, but you do face the risk of challenge if you try to claim expenses as an employee where you have an option to work at home rather than being required. So these are potentially two difficult conditions to meet. In terms of the appropriate facilities on the employer's premises, this might be easier to prove that there are no appropriate facilities if on the days that you work at home, say Thursday and Friday, the employer rearranges the office so that you could not work there. That then leads into travel claims. Typically, it's always been an issue with commuting. Home to work is not a deductible expense, the travel expenses relating to that. But now travel claims could potentially become a lot more complex in this new way of working. The question of what is ordinary commuting comes into play. If an employee is working 2 days at home and they feel that that is their permanent workplace, and they have to travel to the office or to suppliers or customers, they may want to claim a deduction for the extra travel costs. Unfortunately, HMRC's current interpretation is very strict on this, and again, it comes down to, does the employee have a choice whether to work at home or not? And if they do, they're unlikely to get a deduction. So all of this really leads back to the employment contract, the importance of reviewing that to determine whether the employee is required to work from home to be able to claim some of these home working expenses in this new world of working. So that just now ends my part of the webinar. If any detailed questions or advice is required, please get in touch, and I'll now hand back to David.
Thanks, John. And that concludes this webinar. Thank you to you all for listening. Many thanks to John for participating in this webinar with me. I hope you all found this helpful. If you have any questions for John or myself, please do get in touch with us. It's really important to us that we talk about what interests you. So please let us know if there are any particular topics that you would like us to cover off in future webinars. Any material that we referred to in the webinar will be made available to you, as will links to other content from 𝗖𝗄 and Richardson Swift that you may find useful. Thank you for listening.